mentioned that so challenging the order of 144 CRPC.
Sorry?
For CRPC, why the past was public magistrate Chhatrapur.
Yes.
My lord, item number 15 may kindly be posted to next week, my lord.
Page wise. Huh? Page wise. Okay, 15. Yes.
May kindly be posted to next week, my lord.
Which year matter?
My
Or
lord,
90. Okay. Next week.
Let's say item one.
Yes. Sorry?
Noting this in item 15 is that you are filing in 2019.
Steps for limitation not yet taken.
Currently, automatic funds, let them file the affidavit, otherwise they will.
Again, page 1, item number 4.
No, no,
No,
ticket, proper
15 where? Yes.
my lord, we will remove the defect in meanwhile, my lord.
2019 matter, you have not removed the defect you are seeking urgently.
24. That you are filing a limitation.
Kindly.
These are unnecessary pending Monday. On the request of Solar Council, but the petitioner matter is urgent to Monday. It's made clear that no further adjournment shall be given.
Same page, item 14 minutes, these are batch matters. In fact, the matter has traveled also from Supreme Court's law regarding the excess matter, but pertains to the disposal of the rejection and the discharge petition. In these matters, my learned friends, in all those matters, where these matters were before another bench plots, he has supplied me a copy of the note of submission. I have to file the returns plots. And that too, in all those matters, the entry mode is there. What I suggest, let this matter taken off after that batch matters, lordship posted to.
Now, who is for petitioners? We let us see.
Yes, lordship noted, at the time of call, I will also make.
Yes, that's
This may noted, item 14.
yes, item 4.
Let's
yes.
Item 4, my lord, in this case,
Yes.
today I have to file the counter affidavit to the application.
Hmm.
And further, I have filed an application, interim application for its analogous hearing with an CRLMC, which I have filed for quashing the cognizance. That I have filed, my lord.
Now, you are supposed to get instruction.
No, my lord. For that, I at least 1 week time. Because
I have objection.
even Rohit, sorry, sir.
I have objection.
I have, in the meantime, I have collected this bunch of document. I have to file, my lord.
I don't think I need any counter in this.
My lord,
I
this-
will remand the matter back, and the
What
trial
is it?
court will suitably.
435 provisions there, my lord.
Huh.
If the magistrate granted bail, then cancel. If the magistrate himself can cancel the bail on answers of 437.
And I'll relegate and whatever consequences there,
That's disposal. That is the law.
I'll dispose it.
Yes.
Okay.
I only in the state of famine charge.
Yes.
And I will only request your lordships on the court, that your lordship may fix a 6-month time to disposal of the case.
No, that's
Cancel.
Oh, you
Cancel.
Again, more Raji again. 6 दिन हेले भी हम राजी हो.
And it's
Expeditious.
but it is, see, it's in practical. I don't know how many witnesses are there and all.
3 जन again, 3 जन.
3टा witness. More तरफ 3टा witness.
हमें तो
Say the
And he is collecting bunch of documents.
I will exhibit not less than 1,000 exhibits.
So then so within 3 months out.
And I rely on those. I will not exhibit a single document. I will rely on his exhibit.
So I'll just see, I'll observe it.
Your lordship may kindly say that.
I'll observe it, I'll just see. Educate me.
As expeditiously.
Yes.
Let's say item 1 can permit
And
kindly permit to withdraw.
Judgment reserve. Huh?
Yes, ma'am.
Let's say item 1.
437, your lordship has
Yes.
that problem.
Let's say item.
Regarding direction.
Don't worry, I will pass a balance order so that.
नहीं किसी अपन जो order
No, no.
reported case.
ମୁଁ ଆଜି ଗୋଟିଏ judgment
We will follow it.
ଆର ଥର ଯୋଉଟା ଦେଇଥିଲି ମାଇଲ ସେଇଟା ଦେଇ ଦଉଛି Well, I am relying on this.
Who has filed this IA?
I have filed mine.
Achha, I taken on record.
And that CRLMC, which they are saying, your lordship cannot call for it and assume jurisdiction. It is to be listed before Honorable Justice Mahapatra. He really
not my-
hearing.
It's not my
Yes.
board then.
Assignment.
Let's say item 1.
Don't further complicate it. I want to simplify
more
it.
decision किसी दो नहीं आएगा तो.
That's what I said, if the two civil lawyers appearing in a criminal matter. That's the problem.
Let's say
Both of us have been doing for last 10 years. This.
Yes.
let's say item one.
And there are many things to learn from Mr. Bag.
Yes,
He is one of the legendary.
he's one of the civil giants
Civil.
whom I consider,
Yes.
along with my seniors.
There is no doubt about it. There is no doubt. Yes.
Let's say item one, let's kindly permit to withdraw.
Yes. That's the best thing one can ask for.
Pardon your
That's-
lordship.
Edwin.
My lord, I'm mentioning, my lord, there is a criminal revision. Already the compromise affidavit has been filed between both the parties.
Revision
Yes, your lordship.
against the conviction.
Yes, your lordship.
Which item?
Compromise matter, mentioning
I'm
Acha,
mentioning.
or listing.
These you will dispose it.
Lordship, item 20, may kindly be adjourned.
Why?
Lordship, we need,
You have to tell why.
Lordship, we
20.
are unable to contact the petitioner.
See, 2012 matter, ma'am.
Kindly grant me one more date, Lordship.
Legal counsel for the, what, it is against what? Against conviction or against some,
Vigilance. Vigilance, criminal revision.
Which one? Item 20.
20.
Yes, your lordship.
20 more list देखो जी अपन अपन vigilance इधर देखो फाइल फाइल
कोई 2012.
इधर ये अपन list देखिए
Lordship,
Monday also.
अपन list इधर ना not been written page and this must be a vigilance
HK Mundo, SK Mundo.
But 19 is fine. 19, 20.
NIM,
138.
130 enactment.
138.
Negotiable Instruments Act.
Legal counsel for the petitioner seeks adjournment in this matter to take, to seek instruction from his, from her client. This is the matter next week. It is made clear that no further adjournment shall be. Yes.
Obligation.
My lord, item 19, my lord.
Yes.
I have already solved the extra copy and maybe addition to
No, item 19.
19.
No, it's a case of 2012 modes.
No, how, why should we adjourn like this?
The old matters of the law, so many endeavorable things have been resurrected. Now, my lords, again time, sorry, sir.
Fasting.
No, not past time, sir. This is 12.
What
Celebrating
this-
is the one decade.
What is this matter is about?
My lord said that rejection.
Rejection of?
No, my lord. Item 19, a forgery document. Comment.
Hey, you have challenged what?
Conviction order, my lord.
See, the High Court board is plugging because
Yeah,
of
he's
the
correct, he's
unnecessary
against conviction.
pending of-
Yeah, is correct. Against conviction.
Against conviction. Put it in the weekly list. I'll not adjourn it, it will be there in the weekly list, get ready. 2012 matter. Okay,
Lordship,
next.
item number 5 is already disposed of in Lok Adalat and it is infructuous right now.
Acha. Learn counsel for the petitioner submits that the matter has already become
Disposed of.
infructuous.
And
no,
Disposed of in Lok
infructuous
Adalat.
in view of the fact that the matter is disposed of by the Lok Adalat. In that view of the matter is disposed of. Okay, 5 number item.
My lord, item number 21, on behalf of Mr. H.S. Mishra, my lord, kindly taken up next week.
No. The interim order is there, my lords. It's case of 2000.
It is out of session, my lord, kindly taken up next week, any date.
At best Monday, my lords.
This is against what?
Lord, that it has been, the interim order is against us. No?
Conviction. See, 2012, we have interim order, there must not be conviction. Interim order is there means there must be some interlocutor. Prevention of Corruption Act. There is no interim order.
Item 21, my lords.
21.
But the noting said that the cause list indicates the noting, my lords. Further orders.
I mentioned as well. Mention.
It recorded weekly list. Let it be in the weekly list. Yes.
Publishment.
My lords, here the charge has been framed, my lords.
Hmm?
Charge has been framed.
Against charge.
Yes, after framing of charges.
21, huh?
After framing of efforts or charges against petitioner, the prosecution examined the complaint and he's also cross-examined on behalf of the petitioner.
20. Yes, 1 minute. What I see. Also. In except 3.
Yeah.
It is that at the interlocutory stage,
Yes.
you have come. And from 2012, the trial is stalled.
Witness having examined notes. After framing of charge, witness having examined.
Monday. Published. Monday, at the request of learned counsel for the petitioner, matter a judgment for Monday petitioner, and it made clear that no further adjournment shall be given in the event adjournment is sought on that day. The interim order operating since where is that case? Where is the interim order?
The noting indicates, my lord, in the cost list that for further notes.
Yeah, for the but there is no interim order as such. It is heard. This is an application for stay of further proceeding. As it is found that LCR is necessary for disposing of the case, call for LCR. Urgent copy of the order be granted on proper application. Where is the order?
But the noting indicates that it has been further,
Maybe.
because as LCR has come out, that the things have been stored there. Maybe, not. For that reason, it has stated that.
But how have you construed that there is an interim order? And from 2012, things are moving like this. What have you done? There is no order of stay.
They have called
It
for.
is only says this is
for
an
LCR.
application for stay of further proceeding. There is no order made. LCR is called for. You are sleeping over.
LCR has called for, that's why a lot of things have been stored.
This 2012 it is going on. Just see.
Correct.
Imagine. No. I had short for the in the event card deal. On 6/3/2012, the following order was passed. It appears in view of the fact that the LCR is called for, the trial is stalled. In the event further adjournment is called for on Monday, the LCR shall be reverted back to the trial court and trials shall proceed.
I beg pardon to mention a matter, my lords. Item number 9, my lords. On behalf of my learned senior, due to some personal difficulties out of station, Mr. Milan Kanungo, my lords.
9.
Yes, my lords.
So far, item number 9 is concerned. Your lordship may kindly have a glance to the sub item.
Yes.
Sub item since 18/5. I had mentioned earlier before your lordship, since 15/5/23, bail has been granted and also fine has been stayed. Again, the noting is there. Your lordship may kindly have a glance.
What is this?
18/5/23. This noting is wrongly being noted in the list that bail and fine. Your lordship may kindly have a glance to the record.
Oh, noting in the cause list. Cause list
Cause
noting
list
is correct.
noting.
The cause list noting. What is this matter? It is asking
This
for
matter has already been, paper book has been prepared. Let it be listed in the hearing.
against conviction.
Yes,
my
against
lord.
Against
conviction.
conviction. Oh, weekly
Against conviction?
weekly.
Yes.
Weekly, 409
Noting-
and 13.
Noting ignore karo.
Noting ignore.
My lord,
Deeply
I
oppressed.
may kindly forgot to mention before your lordships, item number 31.
Weekly hearing.
That was on, as item number 30 in the yesterday's list. I have mentioned before your lordships and it was posted to 26th of July. Instead of 26th of July, again, this matter today it has come out. Wrongly, my lord.
To,
It will be listed on 26th of
the matter was, item 31.
31.
The matter was listed yesterday and it was directed to be listed on 26th July. Whereas inadvertently, due to wrong noting of the date, today the matter is listed, list the matter on 26th July.
That item 4, the JMFC had passed the bail order. Now the case has been transferred to CGM on good. That portion your lordship has clarified.
CGM on
On good.
CGM on good. Matter is remanded to CGM on good. Matter is, yes. Any mentioning, yes, yes, do you want to mention any matter? Ms. Mahapatra?
No, my lord, I'm appearing for item number 2, my lord.
Okay, yes.
Item 2.
2. On 13.
Item
2.
CRLMA. What is it?
My lord, it's a
Modification of
petition
condition.
for-
What are the conditions?
Wait, more, no, wait.
Petitioner shall not leave the jurisdiction of the court without leave of the.
No copy has been served. That
This
may
is the petition, oh, right.
So
Yes.
your lordship give straight and forward to, he is to leave with the permission of the court.
That's what the condition is.
Yes,
Nobody is there to press why
he
should I.
is to take permission from the court.
I know. The present petition is filed by the petitioner seeking modification of the bail condition imposed by CJM imposed by order dated 24/8/2005 passed by CJM Vigilance in GR case number 15 of 2000 and TR case number 9 of 2012. While granting bail, the petitioner was directed not to leave the jurisdiction, not to leave the condition that the petitioner shall not leave the jurisdiction. Impose the condition that the petitioner shall not leave the jurisdiction of the court without the leave of the court. The matter is pending since 2013. None appears for the petitioner. It appears petitioner is not interested to prosecute the case. Even in the merit, there is nothing.
Petitioner's counsel is in the VC, my lord. Daughter of Gokulan.
Yes, it is dismissed. He is not interested. Yes. Next.
My name can be reflected on behalf of vigilance.
Yes.
This
You
was-
are appearing for in item 2.
My lord, I'm
Yes.
appearing.
None appears ki jagah cut digi, so and so appears. I'm not inclined to entertain. Yes. Next. Yes. Next.
Item 3.
I am representing on behalf of
Yes.
vigilance. Lord, 3 is a matter of 2016.
Hmm.
My friend said they already been acquitted. So that statement recorded. We close.
Yes.
Who is acquitted?
I filed this application for cancellation of bail of the accused persons on the ground that
the
they have been,
yes.
after the religion bail, they committed my lord, another 2 cases, threatening the witnesses.
Anyway, the present petition is in the present petition is challenging the petitioner seeking recall of the bail granted to the petitioner.
Accused persons.
Petitioner.
Petitioner is the informant here.
Opposite parties. Opposite party. Opposite party oblique accused person. Learned counsel for the opposite party submits that. Meanwhile, the
Original case.
opposite parties have already been acquitted in this.
Acquitted.
So there is nothing survives in this matter. Accordingly, it is
Report also. Report is there, madam.
accordingly it is disposed. Yes.
Published.
Item 6.
I have filed this for fixed date of hearing.
It may be listed in the weekly hearing list, my lord. Paper book has already been supplied. And Mr. M.S. Rijvi's name may be reflected in the cause list, my lord. MS Rijvi. Additional standing
Ready?
counsel.
Yes, my lord, next week.
Why 2 o'clock? Huh? Let it be there in the weekly list. Then. Get ready, huh? Weekly list.
Yes, my lord.
Tick. For ALS, yes.
Item 7.
My lord, I am for the petitioner, my lord, but it's a old matter. I'm not been able to connect with the petitioner. And the petitioner, the original petitioner is no more since a long time.
Original petitioner?
Is no more.
Original petitioner, there are 2 petitioners.
My lord, Kalicharan Mahapatra is no more. And there's a substitution petition has been filed. So I am not been able to connect with the petitioners.
What about the Prasanna Kumar Mahapatra?
My lord, I have no instruction because I'm not been able to connect with any of. So 2 weeks time may be granted. I have no Puruna matter.
You could not do so far 2011, the matter is pending. Now within 2 weeks, what will you do?
I'll connect with and get instructions, my lord. That might.
The vigilance case, this is vigilance case.
My lord, it's a
Which area?
This is a confiscation matter, my lord. Confiscation of ill matter.
Special Courts Act.
No,
Under the Odisha Special Court Act.
vigilance, you tell me the vigilance SP. Who is vigilance SP?
Mr. Kalicharan Mahapatra is the which.
Tell me.
Kotak Vigilance. Yes.
Kotak vigilance.
Yes.
Vigilance SP Kotak.
Yes.
SP vigilance Kotak.
Kotak.
Right.
My lord.
Already counsel for the petitioner submits that insofar as petitioner number 1 is concerned, he has already expired. So therefore, an application is has already been moved by the LRs to continue with the appeal. Now, whereas the whereabout of the petitioner number 2 is not known to her. In that view of the matter, she seeks 2 weeks time. Urgent matter to after 1 week. Meanwhile, the SP vigilance Cuttack is directed to file a status report regarding in regard to
Authenticity of the whereabouts of
petitioner number 2 is concerned.
appellant number 2.
Appellant number 2 is concerned.
And my lordship, appellant may be directed to serve the copy of the substitution petition so that
Appellant is
I will serve.
directed to supply the copy of the appeal paper book along with the
substitution.
the application for substitution. Release the matter, date the.
Two.
Give a free copy to him so
Yes.
that he'll give it to the.
Obliged.
I
Yes.
will.
Yes, sir.
8 page rods.
Yes.
So this is an application filed by the petitioner, who is the appellant in criminal appeal number 186 of 2022. Under section 389 of the Criminal Procedure Code, for stay and suspension of sentence and conviction passed against him, madam.
Now today it is listed for what?
First, that madam, for stay of conviction. It was interim order was passed by this honorable court.
Sentence is suspended.
Madam, no, madam. Interim order was passed and it was posted for judgment, but it was released from the. Well, let me see the last order passed by Honorable Justice Mahapatra, madam. It was released because judgment could not be delivered.
Interim order passed, earlier shall continue next day deputy.
Beforehand, madam.
We request leave the matter.
Virtually, my learned friend appearing for the vigilance has given his written note of submission and citations. I have also given my written note of submission and citations. I just want to add 2 more orders.
Why it was released?
Well, in many cases have been released. Perhaps well, during that period, some order was.
Your lordship may kindly have a glance to order dated 12/7, 2022.
Yes.
12/7,
Hearing on both
2022.
the sides are concluded, judgment is
Thereafter, your lordship may kindly have a glance to the order dated 14/12/2023.
Now this matter is taken up so and so. Place this matter before acting chief justice for releasing the matter.
Because
After 1 year and 5 months, it was again released and.
because say around 50-60 cases on that day you were listed and 2-3 matters were kept and everything, all the matters have been released.
This application was had at length from my learned senior friend and
But
my.
I am not interested in hearing application. I'll hear the appeal itself. I put it in the weekly list, get ready for appeal. That's the best way of doing it.
There is also an application filed by my learned senior friend.
For
That is IA number 21.
For stay of conviction,
For
No, no,
early
no.
hearing, for early hearing.
Your lordship,
early hearing allowed.
524 of the kindly be paid.
Early hearing, that is early hearing.
Early hearing
No,
allowed.
it is fixed. It may be disposed of.
Application, early hearing application, 500 it is allowed. Release the matter in the weekly list for final disposal. Get ready whenever you are ready. Tell me at 2 o'clock. I'll take it.
My lord, my lord.
Yes, I have got all the deposition copies.
Oh, hella.
Shall I fix a date?
Yes.
When?
No. The weekly list, it may come in the weekly list. I am ready. I will ask. Let it come in the weekly list.
2022, yes.
23. It is 2022.
Finish totally.
Weekly list, eh?
Oh, my lord, you
Early
see.
hearing up. Okay.
Ah.
Sure. Yes.
Interim order, that order.
Interim order to continue.
Interim order, I have filed for stay vacation of that.
But that is interim order. I can't alter it without hearing.
No. My application may kindly be disposed of. I have filed one.
Dispose of means.
Before your lordship, I have filed one.
But what will I do? Shall I dismiss
Your
it?
lordship should consider that.
Consider means main matter. I'll consider the entire matter and finish it up. Hearing that application, it will take. I will not hear more than 20-30 minutes.
Because of this no coercive action, government is handicapped.
I know that. So I am fixing
I
it.
am being called upon to explain why the such order is going to be continued. I am to explain before my authority.
You should have gone to some
So
better,
why
better
this
court.
it remained, the judgment was reserved for the 2.5 years, and this order is continuing. Government is handicapped, and government is writing letter to the AG. AG is calling for our authority. Authority is asking me.
Now
This thing is happening.
Now nobody will call. There is no AG.
Yes, my lord. It is.
There is no AG.
So my pray that no interim order should be there, or my
No. I can't.
my vacation
See,
order.
the interim order has been operating for such a long time. Matter was heard, judgment reserved. It was released. How can I vacate the interim order like this without hearing the other side? Wrong, right, whatever. There was an interim order. You have moved an application for vacation of that. Get ready. Shall I hear it at 2 o'clock? You come and hear the appeal. I am ready to hear the appeal and finish up.
Yes, I will argue the matter. I am ready. I will argue. I am ready and there because I am being called for
That's
the
what I'm
action.
saying.
Yes.
You give a date so that I can hear the appeal and finish it up.
No, today 2 p.m. I am ready. I will argue.
2 p.m. give them.
2 p.m. I will argue the matter.
Okay. Next week, any day, 2 p.m. You
Well,
tell me.
next week, my lord has already fixed up 3 matters on 1, 3, 4. Sinta case achi July re. Second.
But this matter, see,
Second week of ballot fixed up this matter on 16th, July 16th, specifically at 2 p.m. I have no objection.
I don't know.
No objection. I have no objection for hearing on any date. Only that I have filed the petition.
Mr. Das, and counsel for the petitioner, is insisting on his application for vacation of the interim order passed by the court. Which item is this?
Item 8.
8.
Interim order passed when?
It was passed long back ballot in the year 2022, I think.
The interim order passed on 22/3/2022. Since the matter is fixed for final disposal, I am not inclined to entertain this application. However, it is made clear that no further adjournment shall be given on the next date of hearing. The appeal shall be heard finally.
Without paperwork ballot.
Without paperwork. You take the.
Without paperwork in the sense ballot, we will supply the copy of the deposition.
Whatever existing paper.
You supply whatever documents you have, you supply me. I will argue the matter.
Without any.
Ballot.
Yes.
The documents and the
खाली
charge.
Yes. You people have already argued the matter for.
Yes.
Then you must be having everything. Yes.
Item 10.
10.
16th, my lord. It may be fixed to 16th at 2 p.m.
2 p.m. Yes. Yes, sir.
That's item number 10. I'm there. That's
Yes.
item number 10. There is an IA for stay of conviction. That's my learned senior for the Vigilance Council was to file his objection to the
What
application for
objection
stay of
you tell
conviction.
me, this appeal is of which year?
2024, my lords, this year.
24.
24.
24.
Conviction I am not going to stay. If you want to argue the matter, I can hear. Urgent,
My lords,
simply
may
urgent.
then in any event, paper books may be permitted to be placed on record so that it can be
Yes.
put up in the hearing list.
Let him
Next.
prepare the paper book at
Next.
his own cost. At his own cost.
Prepare the paper book and come and we'll do. Yes, next 11. 10 urgent को दिया, आगू.
They will prepare the paper book at their own
July
cost.
लाके.
10.
Yes, sir.
11. But 11, your lordship remembers, I have filed that application for stay of conviction. Your lordship was pleased to observe that the document in support of that plea taken in the petition for stay of conviction was not appended to. So with your lordship's kind.
No, I said that if you give document, at least they will be in a position to file reply.
Much obliged.
Where is the document?
I am filing it with your lordship's kind permission today, and I am giving a copy just with me.
Yes. Mr. Mishra, and counsel for the petitioner, hands up the documents in support of his application, IA number?
And that is IA number
1465.
1465.
1465.
I chose the phone, yeah. Mr. Das submits that in view of this document, he would be filing reply to the said application, release the matter.
2 weeks after.
2 weeks after.
What a date they fix for that.
Date fix. Date he will fix it.
Let him supply the
He is
copy.
fixing it.
I do not know. I am giving a statement.
Yes,
Matter
yes.
is recording.
After receiving the copy, I will file my objection.
That's what I have recorded.
Within 2 weeks thereafter.
Release the matter on 18th. 18th July.
19th.
19th July, okay.
19th.
19th.
17th छुट्टी होगी ना?
Yes.
Item 12.
Yes. 12. 12. This matter is pending since password correct. This matter can be disposed of. Just see.
13.
Mr. Das, this matter can be disposed of. Just check it up.
Item 13 minutes.
No.
12.
I'm passing it over. Just check it.
12 vigilance.
This is. A non-APS for petitioner in the last date also. It's pending. Pass it over, then I'll dispose it.
13.
Well, item 13, I was taking instruction till date, charge sheet has not been filed.
That's if a lordship permits, may
13, huh? Let me understand. Yes.
That I may release, we have filed an application, there is a delay of, in fact, 2 months.
What is this, what is the prayer?
This is, my lord, I have prayed for release of the, my lord, my passbook and ATM cards which have been seized by the vigilance police. Thereafter, I have filed an application 457 that has been rejected in the year 2014. Till date, my lord, charge sheet has not yet been filed.
Lords, you can turn to the last order dated 12 March 2015. 12th March.
Yes.
Lords, you got it, Lords?
12th
March 2015. Lords.
Yes. That's there. 12th March 2015. And counsel the petitioner prays for withdrawal of the application with the liberty to file a better petition. Considering the aforementioned submission, the Miss case stands dismissed. And counsel the petitioner is permitted to take back the certified copy and file a substitution of Xerox copy and so on. So what is use of this?
It's a miscase count of my very good.
Forget about miscase. Main case you say 3, 4 for 57 application. He has moved, and that was turned down. He is there before this court. So far, the charge sheet has not been filed. When the FIR.
No. Charge sheet is a case of 2014.
No, charge sheet has not been filed.
That's what he says. 2013 FIR. You don't file charge sheet.
Let him take instruction. Let it come Monday or Tuesday.
Yes.
Charge sheet has not been filed.
That's why I'm suggesting. I am expecting the instruction by today, Lords. Let it come Monday, Lords.
Monday.
Because 10 years, no, in the meantime.
Yes, I have taken instruction
I will
yesterday.
allow, I will allow it if the charge sheet is not filed. I'm not going to issue.
I'll just verify.
How can you not file charge sheet for?
Code data, right? Last date. Charge sheet file in coach. Instruction co stays.
Till now, no charge sheet. I'm court room. No charge sheet has yet been filed.
See, the FIR was on 13th December 2013.
Yes, 13.
And you have taken his passbook, whatever you have taken. It's all right. You have taken, you have right. 102, you can seize, you have seized. He moved an application 357,
I appreciate a lot.
which was rejected. He has approached this court. You don't file the charge sheet and you take away everything. What is this?
No, I'll find out.
Not only I will allow this, I'll impose some cost also. So that the business people will understand. What is the trauma being undergone by the.
Not charge sheet by the 10 years is good enough. I will verify.
And it is a matter of for quashing.
Another matter I am also moving, in 2012 matter, they have also in that matter charge sheet has not been.
File quashing, it should be quashed in fact.
I'll file my lord, that application.
13, 14 years you don't file charge sheet, what is this? Monday, it's made clear that no further adjournment shall be given. See, that is how the courts are completely, plugged. Litigation after litigation. Yes, next. 13. 14, yes.
14 13. Is that matters, my lords.
This is the 13th pillar. 14, yes.
Lords, 14 before my learned friends starts his case, my lords. My lord, this batch of matters, my lords, and my learned friends good enough to serve a copy of his written note of submission, my lords. I have to file a return, and its case was before this another courts, before another bench, my lords. And in fact, this case
this is against the application for rejection of discharge application.
Lords,
What happened thereafter?
Lords,
Charges been framed.
No.
Stay.
It had been stalled, lords. But in the meantime, lords, what I suggest, lord, this matter may be taken off after that particular batch of matters, lords, fix in Mr. Kanungo's matters coming. Next day.
Is it connected to that?
No. This batch matter will be taken off after that, lords, because that case is coming on 15th, lords. I'll be filing a return to my learned friend's note of submission, lords. It's 4 cases.
The stay is operating since last
yes,
so many years.
In a while, can I say, in a not subject to
No, yes, please proceed.
It's a question of fixation of MGQ of a distillery. Fixation of minimum guaranteed quantity in respect of a distillery. Let us grasp it. Your lordship will hear it as my learned Mr. Das request.
Right.
MGQ, minimum guaranteed quantity. Now there is a set of rules for that.
You are the licensee.
I am the licensee. I am the distillery owner. Now there is a rules for that. The rules say that it is the Commissioner of Excise will fix the minimum guaranteed quantity in respect of a distillery or licensee as the case may be. Now here in this case, Commissioner fixed a specific amount, extent of MGQ for this distillery, say 1 lakh liter for us. Commissioner fixed it. Now, contrary to that, the state government had an executive instruction that in terms of installation capacity as fixed by DIC in its registration certificate, 50% of that will be the MGQ.
There is a contradiction.
So one instruction is there, one rules is there. Now Commissioner fixed the MGQ in terms of the rules, in terms of the file process from the down below clerical level up to the Commissioner. Now MGQ was fixed, we lifted the MGQ, we paid the revenue, whatever we completed. Now, thereafter, good time thereafter, audit took place. Audit raised an objection that look, the DIC registration installation capacity is the basis for fixation of MGQ. How do you fix the MGQ on the basis of the rules instead of abiding by the DIC registration? Kindly, what happened thereafter? Now, there is be a demand against that. Because based on audit objection, there is be a demand. I challenged the demand before this Honorable Court. This Honorable Court dismissed it. My review was dismissed. I went to Honorable Supreme Court. Honorable Supreme Court, considering the whole aspect, audit and everything, gave a detailed order that it is the Commissioner and Commissioner exclusively has the power under Rule 6C. Since Commissioner has fixed 1 lakh liter, that demand is not sustainable in law and that is final. What's the demand? What remains thereafter to be decided in vigilance case?
What is there? What is mens rea in this?
That's it.
If the, whatever he says is correct.
Yes, I filed the commissioner's order, I mean, on
Nothing.
There is also, it involves some two arguable points, I will disclose, fix a date after that batch matter.
I am fixing, but what is this?
No, my lord,
the trial court
Unnecessary
cannot-
bargaining. How many matters are there in this?
Like 4 matters, some employees have been roped in. Lord Ajit, the trial court has sat in appeal against the Supreme Court.
The findings are obviously binding. If MGQ fixation is the only issue
Yes,
to set the criminal law in motion,
yes,
and that MGQ issue has been subjected to adjudication by the Supreme Court,
Yes.
what else? It is binding on you. You can't
you can't
get
sit
out
in
of it.
appeal.
You can't get out of it.
You can't sit in appeal against the
Yes, yes.
Supreme Court's order.
No, we are not sitting.
That may be the reason the court has rightly discharged.
Yes.
I'll approach your lordship with the different circumstances there on Supreme Court.
Right.
Lordship,
When do you want?
the last batch matter, Kanun Govam ko
No, you forget about that. This is a small matter.
Yes.
You don't relate with that matter. You
It can be next week sometime.
put it next week. 4 matters will be over.
My land senior will agree sometime next week. How would the tinta
Put it on Friday at 2 o'clock.
That will be fine.
Friday 2 o'clock. Next Friday 2 o'clock. It's made clear that no further adjournment shall be given.
Yes, sir. And the interim arrangement to continue.
Interim order. Yes.
Next
Friday at 2 o'clock.
Friday.
So that Saturday, Sunday we can utilize. Yes. No further adjournment shall be given. And come with whatever small note of preparation and all.
Item 16.
Yes. Discharge. There is no stay operating. So what happened? His discharge application was turned down.
My lord.
He has come to this court. What happened in between the charge is framed? 2019
My lord.
discharge application. This is item
Item 16 here.
16.
এটা তো জি এটা 24 বছর
16.
my lord, only this matter will go to another bench, my lord. But
Still MCA. Why?
Only correction, my lord. What happened, my lord? Instead of IA number 1273, it has mentioned in the order sheet, my lord. Order dated 20th 5/2024, my lord.
Huh?
Order dated 20th 5/2024, 25 ରେ
Yes.
ସେଥିରେ IA number ଟା ଭୁଲ ହେଇଛି ଲେଖା
Could I number 127?
my lord.
It should be
1273.
1273 1273 ହବ
127 ଜାଗାରେ କୋଉଟା ହବ କଣ ହବା କଥା
1273 ହବ
3 miss.
3 message.
Correction code दियो. Correction. 3 missing. It is your problem. You have done it.
Item 17.
Allowed, huh? Yes. Yes, 17. Government to 2011. Appeal.
Yes, my lord. So this is a confiscation appeal against the final order. And nobody is appearing, my lordship. It is pending since 2011. And enjoying the stay, my lordship.
Pass over karo, dismiss karo, lunch karo.
Yes.
Because against the confiscation order, if nobody comes, then I can dismiss in default order.
Yes.
Amicus curiae is not.
Once
required.
they are
It's
taking.
not against
Yes,
confiscation.
my lord. So they are taking it. Stay.
Pass over karo.
18. Item 18.
copy not serve, my lord, private party.
My lord, 17 টা pass over. Pass over.
Private party.
138.
My lord.
Nobody appears. It's pending since 2012. Just imagine. Who is the lawyer? None appears on behalf of the parties. This is the matter. This is a matter arising out of the proceeding under section 138A9. The petitioner has been convicted by the court. This revision is preferred against the order of against the judgment and order dated 7/12/2011 passed by the Court of Additional Sessions Judge cum Special Judge Vigilance Baleshwar in criminal appeal number 47 of 2010. The matter has been pending since 2012. After the matter was admitted on 13/1/2012. None of the parties to the proceeding have appeared. Although the matter was listed many times thereafter. In view of thereafter, it appears that the petitioner is not interested to prosecute the matter. Dismiss this. Twenty-two.
No, item 20, your lordship.
22 notice was issued to the petitioner. Let's see. It is against convictions. What is your order? This is what? Arising out of what? One 30. Right. The present petition, the present petition is arising out of a complaint under section 138 NI. NIS. The trial court. I'm dismissing it. Not wait like that. JMFC first class, while its judgment dated 27/1/2009, convicted the petitioner, convicted the petitioner for offense under offense under 138 NI. The petitioner preferred appeal. Preferred appeal before the court of learned court of learned additional sessions judge, being criminal appeal number 16 of 2009. The appellate court by its judgment stated 30/11/2012 dismiss the appeal. Dismiss the appeal. Dismiss the appeal against the said order. The present petition is filed on 7/11/2012. The matter is pending since then. Yes. For many hearing, none appeared from the petitioner, and eventually on 18/12/2023, letter counsel for the petitioner recused himself on the ground that he had no instruction. Notice was issued to the petitioner, but nobody appears for the petitioner. In view thereof, the petitioner appears the petitioner is not interested to prosecute the present petition. Accordingly, the petition. Yes. 23.
The confirming judgment, revision against the appeal by the order dated 24/6/2024. First time for us.
Yes. Yes, sir.
Yeah, for admission.
For admission, it's already admitted. Interim order is there. Are you sure what is this matter is about?
My lord, revision against the appeal, confirming judgment.
Yes.
Passed by the London Sessions Judge Kendrapada. By the ST case number 8460 AC 60 of 2024.
Convicted for what are the
5
offenses?
years for offense.
5 year sentence, 307.
Yes. 307.
We put it in the weekly list. Get ready. Yes. Next.
24.
My lord.
Yes.
Offense alleged against the petitioner appellant.
Second
Petitioner.
confiscation order.
My lord.
Yes.
Under section 376. My lord, there is no ingredients to allege the petitioner in the said offenses as the FIR has been lodged after 14 days.
It is a conviction under 376.
My lord.
Yes.
And there is no any materials to show that is involved. This is due to personal enmity has hosted this case.
Yes.
My lord. Offense alleged against the petitioner as per the prosecution story of the date of occurrence on 20th
Yes.
8 to 2006 and
Prosecutory is PW?
PW1.
1.
My lord. And
Well, let us read the prosecution prosecutory version. Read it. I am the informant.
My lord.
Read it. Prosecutrix. Do you have evidences or not?
Evidence was
Page 27. Yes.
27.
Paperwork is there.
My lord.
Paperwork is there.
My lord.
It's all right. LCR is there. Sir, are you ready?
My lord. My lord.
Are you ready to argue? Because this is a matter of which year?
The evidence was
14.
not in the
And
file.
Conviction by both the courts below for offense under section 376.
My lord. There is no medical evidence, and after 14 days they have lodged a FIR. And as per the prosecution story, the difference between the house of the petitioner.
Put on the mic.
My lord.
Mic.
The distance between the petitioner and the victim girl is only 50 feet distance, and it has been lodged that he has been detained inside the room for 14 days, for 3 days, and thereafter after 14 days they have lodged the FIR.
So read the prosecutrix version. Why should it be doubted? Just tell me.
Prosecutor story. Evidence.
If you are not ready, then I.
No, my lord. I'm
then
ready.
On 20th August 2006 at about 8 p.m.
My lord.
Of the night, when I was returning to our house from the house of one Diga Barik, our neighbor, after witnessing the TV, the accused Sanjay dragged my mouth by a cloth and dragged me to his room at his house, and having confined me there and having threatened to kill me, forcibly committed rape on me he kept me in that room for 3 days. Only on the strength of the prosecution evidence. Prosecutory evidence.
Accepted the incident.
Huh?
In village committee, he has accepted the incident. What more is left?
But what are the evidences recorded by the village committee? Anybody has
Village
come?
committee has not compared.
But the 3% has given that that was the discussion.
He has accepted that.
Yes.
My lord, I will.
Weekly list. And come with some judgment, written note, something. Yes. Yes. Next.
25.
May I please, Your Lordship? On behalf of my learned senior, Mr. B. Prasad Das, the sub-item 2844 of 2015 has become infructuous.
Infructuous. Write down. Sub-item.
Charge both the cases.
844. Yes.
Airline counts for the petitioners submit that the matter has become infructuous. Dismiss as infructuous. 844 of 2015. Sub-item. Yes. Whatever the main item?
In fact, both the persons, Ratan Kumar Sahu, the second case, Rasmi Patnaik minutes. The charge sheet 8 minutes and charge has been framed minutes. And minutes.
So both the cases are infructuous.
Yes, ma'am.
Huh?
Charge has been framed against both. Let's turn to the second case, page
Now,
42
second
minutes.
case is over. Infructuous.
In that case, also the petitioner number, the first case will charge.
The first case is what? First.
Let's return to the page 42 of the annexure 5 of the second case that which we say that infructuous. 844/2015. Let's have a glance, my lord. Page 42, my lords.
Yeah.
Here the Rasmi Patnaik and Ratan Sahu both have been charge sheeted. I mean, charge has been framed. Charge has been framed in the month of October 2015, my lords. Now we are in 2024 minutes.
Is the framing of charge?
Both, against both.
Right now, the petitioner challenged the order dated 8/10/2015 passed by the Special Judge Vigilance, Bhubaneswar, whereby charges against the petitioner has been framed. How many petitioners have charges?
2.
Petitioner have been framed. Since the charge was framed long back in
October 2015.
Long back in the year 2015, trial might have already proceeded.
In the absence of any interim order.
Trial substantially might have proceeded. Mr. Das, the counsel for the opposite party submits that nothing survives in the matter because trial has already proceeded. In that view of the matter, the matter deserves no merit. I can dismiss. Yes.
26. The 26, the conducting counsel is out of town. I may be permitted to place the case on his behalf, madam.
Yes.
I don't have power. If the lordship permits, I can place. If the lordship permits, my lord may submit. This is a case where the charge has been framed against the wife on 109 minutes. Lords, I'll just place 2 judgments, my lord. Let it come tomorrow or Monday.
No, was there any interim order?
No. Interim order is there, man.
Is there?
Yes,
Interim order dated 7/4/2022.
7/4.
7/4/2022 interim order is there.
But this revision is directed against an order framing charge, lords. See under 109 IPSC murders, abetting the husband's murders.
But interim order says.
Is there.
Says that it is open for the petitioner to seek adjournment in the matter before the court below. In the event the application is filed, the same shall be considered on merit and shall be adjourned. Next W. Matters are trial is not proceeding.
No. In fact, the husband has died.
What happened in the case of husband? It is separated?
No. Both.
Trial is separated?
Both are separated.
Then trial is stalled then?
Yes, ma'am.
Because of this?
Yes. And all the points can be raised there. All the points. And now she said that I'm
you have independent defense?
No. Yes.
I have
filing
independent defense.
Independent income tax return.
You have to face the trial.
Because my lord, nothing is against me, my lord, in this case.
No, she has been
That
filed
will
income
be
tax
tested in the
returns.
trial only. If you have any independent defense, apart from your defense of your husband, then you have to establish that in the trial. If you don't have independent defense, you simply say that it is all my husband's
husband's,
property,
Lord.
it was in my name, then you are out.
I'm a passive.
Yes, that is my judgment.
Now here is the case where she said that I have come tailoring business. I'm paying that income tax returns and our constituted house from the money I received from my fathers.
That returns are
That's the
not been
defense
taken into
plea, my
account,
lords.
my
That
lord.
defense
But
plea
you
can be
argue all
raised.
this point there.
Defense pleas can
Lordship
be
may call
raised.
this matter tomorrow, day after tomorrow, the conducting counsel may be present and would satisfy your lordships. Because he is not there, I am on his behalf.
Tomorrow. Yes.
27.
Final item 27 permitted to withdraw.
Both, all the matters, there are how many?
No, 27
Two.
charge has been paid. He has filed a revision against order rejecting discharge application. In the meantime, my lord, charge has been paid. Most likely, my lord,
Both
he'll
the
come up
matters.
with another.
But both the matters, huh? Both the matters. Right. Then counsel for the petitioner seeks to withdraw the petition. Both the matters, huh? File the memo.
27.
Dismiss as with.
27.
27.
Dismiss as with. Yes.
28. Petition we have.
Hmm?
47 we have also Excise Act.
None appeared on behalf of the petitioners. No, nobody appears what to do.
Both the courts, my lord.
None appears. 47.
My lord. 32 bottles of Kisan 3x rum and 5 bottles of Club 4000 beer.
Sentence?
Sent 6 months. 6 months, fine 500. But in fact, when the constable may not see the materials.
Constable, no independent witness.
No independent and produced before the SI. A good case for.
No expert opinion.
No,
you come. I'm talking about you. You can come, madam also can come. I'm appointing a MA query tomorrow. There is nothing we will execute it. I good. Huh? When the matter none appears for the petitioner. In the previous occasion also none appeared for the petitioner. In that view of the matter, I'm appointing Anima Dei, counsel present in the court as an amicus query to assist this court. Leaves the matter for hearing tomorrow.
But what happened whenever your lordship engage the.
Mr. Raghuda has already argued for you.
Their name not reflected in the cause list.
Cause list he should reflect. Cause list.
So that they.
You take, he will assist you. There is only the constable, the recovery witness. There is no independent witness. And 47A of what you call BR and Orissa Act. In the case of 6 month sentence. Either acquittal or PO. Yes.
29.
Tomorrow, huh? This one? Yes. Yes.
29, my lord, last occasion I had requested to delete the name of Mr. Gautam Mishra and associates.
Sorry, I am not able to follow you.
My lord, last occasion I had requested to delete the names of Mr. Gautam Mishra and Advocate D.K. Patra. We don't have any instruction in the matter, and your lordship has already issued notice through court process.
No, this is against what? This is against conviction.
Yes, my lord.
For offense?
376, ma'am.
Service service.
ମାନେ ଆସୁନାହାନ୍ତି ଇନଷ୍ଟ୍ରକ୍ସନ ଆଉ କିଛି ଜଣା ନାହିଁ ନାଇଁ ମାନେ ଏମିତି ଚେମ୍ବରରେ ଅଛି ତ ସାର୍ଙ୍କର
The counsel appearing for the petitioner has recused himself to appear in the matter for the lack of instruction. from his clients. Therefore, the notice was issued to the petitioner by this court on 21/6/2024. However, none appears for the petitioner. In that view of the matter, Mr. Aguda, tell somebody's name, who can really do it? Mr. Anjani Bishwal? Bishwal.
Anjan Mishra.
Mr. Anjan Kumar Bishwal, counsel for the land advocate, is appointed by this court as an amicus curiae to assist the court. Copy of the paperwork copy of the paperwork may be, the registry is directed to supply copy of paperwork to Mr. Bishwal. List the matter. Next year. Call him. The name of Mr. Vishwal reflect. amicus curiae. ठीक है? फोन करके देंगे.
Item 30. This is a case, item 30.
Yes.
This is a case, my lords, in a case of trap case, my lord, the person, the accused was a letter of lords. Then state has come up with an application for a grant of leave. Leave was granted. Today is for the hearing. I'm conscious about his case that the person is now ailing and at the flag end of his life, lords.
90 years.
No. 87 at the time is correct. I don't stand on the way. Let it come tomorrow. I'm not gone through it. Only three witnesses. PW2 is a decoy, and the PW4 is shadow witness, and PW5. We rely on the entire prosecution can hinges essentially on the decoy statement.
Let him die peacefully.
No, I still then I have to assist your lordship for passing the order, sir.
Tomorrow. And thereafter, 31. Hearing matter. We'll take the password also. Hearing matters. Password. One password is take it. Password.
Your lordship, this matter.
12.
Your lordship, this matter will come tomorrow.
Tomorrow. Yes.
Obligation.
Password. 12.
Item 12.
What is this matter is about? The present petition is filed challenging the order dated 14/11/2011. 14/11/2011. This is challenge what? Had the question of stay of impugn sentence fine. And then a fine stays subject to the condition that depositing the half of the amount. Say order dated 14/11, whereby the sentence of a fine imposed on the petitioner was directed to be stayed subject to the condition that he should deposit the half of the fine amount. Half of the fine amount. The matter is pending since 2012. In the earlier occasion also, none appeared for the petitioner. On the second call, none appears for the petitioner even today. In that view of the matter, it appears the petitioner is not interested to prosecute the matter, hence dismissed. Yes, sir.
17.
17.
Well, this is the
Challenging what?
My lordship, they have challenged the final order of confiscation
Confiscation.
dated 7/3/2011,
Is pending since?
pending since 2011, my lord. And they are,
Confiscation order. Huh?
yes, my lord.
This appeal is directed against the
Final order.
final order and judgment dated
7/3/2011.
7/3/2011 passed by the authorized officer,
Authorized officer, Special Court, Bhubaneswar.
in confiscation case number 2 of 2008.
Yes.
This matter is pending since 2011.
Yes, sir.
None appears for the petitioner. Even in the previous occasion, none appeared for the petitioner. In that view of the matter, it appears the petitioner is not interested to prosecute the matter, hence the appeal is dismissed.
Yes, sir.
And
Both. And 3 copy of the order.
appeals arising out of confiscation can be dismissed for default. It is not a conviction, so why should I appoint a magistrate?
That is the inquiry, my lord, sir.
Yes. Be dismissed.
3 copy of the order, may kindly.
Free copy of. Yes. Thank you. After lunch, hearing.
From appeals starting from 90 to 2000. In all appeals, on these appeals, I have sent the letters yesterday itself for well-being and whereabouts. So hopefully by next week, these letters will be coming back, the reply.
No, you give the appeal numbers.
Appeal numbers, my lord,
Appeal
sir.
numbers so that I'll pass separate order. There should be order. Instead of you writing it,
My lords.
that will remain in your file. There should be a judicial order.
My lords.
Thereafter, what I'll do is, I'll request if nothing is, no result is coming forth, then I will request the Director Vigilance
My lords.
to appear in VC and try to find out some way out.
My lords. But we have sent that letters, my lords. We are hopeful that something will come out because
But
earlier also, my lords, when we sent.
Let there be a judicial order. Give
Yes, my
the
lords. Yes, my
appeal, a common order I'll pass.
Yes.
In all the files, you will put
My lords, from item numbers 92 till 100.
92.
92.
What about this?
My lords, 90 yesterday, your lordship has heard and judgment is reserved.
90.
Yes.
Yes. What about 87?
87, my lords, I have the whereabouts. I was having the whereabouts.
Is there any order? Director to place before the okay. This is on Monday.
Yes, my lords.
87.
Abdul Hamid also, my lords, in this case, 88 years.
Next week.
89 is on 5th. 90 was heard by your lordships yesterday. Judgment is reserved.
Yes.
From 91, till 123, my lords. These are all appeals of the year from 90s to 2000. In these cases, my lords, the judicial order can be passed.
Yes, 92,
91 to 123.
91 to 123. Separately लिखो. This appeal is pending since. देखिए दो. Co-year, since year so and so. The status of the appellants.
Present well-being and whereabouts of the appellant.
Present status of the appellant. Their present well-being
And whereabouts.
Yes, are not known. Not known. Therefore, SP vigilance bracket vigilance. So file देखियो को SP संगना लिखियो is directed to inquire about the whereabout of the status and the whereabout of the petitioners, appellants, and place a report within a week. Within a week. Release the matter, all this is a matter. Next
1 week after.
I will card you. 1 week after.
One line may be added. If they were alive, then serve a notice upon him, their case listed before the High Court for hearing.
That can be done if nobody appears for them. If
Nahin.
somebody appears in between.
And the SP vigilance is also directed to serve this the present order, indicating therein that the matters are listed for hearing, final hearing on good date दियो on date दियो हाँ 9 हाँ सबुरे 9 दियो 9th जाएं युड़ा को delete कर दियो true 91 to 129
So that they will contact their advocate or they will engage some other no advocate.
My lords, lords, may I pray? Those matters may be fixed on 15th. If they get 2 weeks of time, my lords, they will do a local inquiry and all those things. Otherwise, in 1 week again, they will come and seek for some more time. 15 will be better.
So it is made clear that the matters shall not be adjourned.
No further adjournment.
No, it make no further adjournment.
Yes, madam. Hopefully something will come out.
None appears for the appellant.
Maximum cases you see they might not have.
92 cases not true.
May I have a submission, my lord, sir?
Yes.
With regard to the criminal revision matters, my lords.
Yes.
My lords, I have in charge of all the criminal revision matters where the Fishy Act is involved. My learned friends take care of the appeal matters. Now, these matters were on different benches for the last several years. But it gathered momentum after this matter assigned to this honorable bench, my lord. 13 revision, all matters are disposed of, my lords, which were in the cold storage. Lordship, practical were resurrected listed, my lord. In last from Monday to till today, 13 revision has been disposed of. Today, including 3 revision disposed. What I suggest, my lord, I will supply the pending list of from 2007 to 2014, which are within 10 years. So all those numbers I'll give to the court masters, my lord. Those cases listed, my lord. That's the reason so many cases can be disposed of.
Yes, that's what I'm saying. Many revision petitions,
and that is one of the reasons
for infractions by now.
Correct. And also that my lords, it is already settled that any plea for the defense counsel is to be tasted in that particular trials, not in that stage, because the roving inquiries or many trials not permissible. And so
many revision against charge and all, they've come and taken a stay and jolly well.
LCR being called for that things are installed there also. So what I suggest.
What is LCR? I don't know. In the framing of charge, where is the question of LCR? LCR is not created.
No, this is another way to stall the matters, Miller. And Miller sometimes.
And the prosecution is also not moving application or anything.
Correct.
Framing of charge, you call for LCR, but where is the LCR? LCR is not created then.
So,
after this digitization, my lords, now the question of keeping the LCR in the court doesn't arise. It is being scanned and immediately sent back.
No, there is no. Nowadays, this trick will not work.
This thing will not.
This will not work. So then you, sir, you give the numbers and they list it.
from 2007 to 2014, all the pending revision matters. And I assure this on courts, most will be.
You give the list so that it will be listed Monday, Tuesday, any day.
And that is one of the major reasons for which today any of the revision against the conviction or any other matter we requires further hearing or some where it is required to delve deep into matters. I deliberately take times, facilitating all the small matter dispute.
The matter which are infractions, at least those
Like
can be-
tomorrow, let's say.
You give the list. List is on. Yes, yes, madam. 91.
The problem is that the paper books are not been prepared till today.
What is the offense?
Yes, and the 409 of the IPC.
Yes, sir.
Paper books are not been prepared.
Solution
Has not been available.
You forget about paper book. Take the evidence from here. Take it, get a pen drive.
Entire LCR will be helpful.
Everything is there. You can take it. So let it retain in the board. We'll see. Let it retain in the board.
That's in all those matters, copy of the order for communication.
Yes. So we order the so go to copy. Free copy.
Another things, my lords, I lordship directed the concerned SP to be verified from the records. But to apprise your lordship, my lord, there are 6 divisions, the entire state. My lord. Suppose in Cuttack divisions, Hon'Ble also comes from Deccan divisions. There are 6 divisions. My lord. So it may not be convenient to the court masters to find out the.
From
in the
FIR they
SP.
can get it. No? From FIR like
FIR.
they will get it.
Now there is a diverse division.
So one example so to have so that she can find it
Yes,
out.
ma'am. I will show her.
It will be.
Now there has been bifurcation of divisions. New Raulukula divisions come on.
Good cases good your check that.
My lords, I will help.
And any matter which could be heard. 22 jai to kala, nahi? 23.
123
123.
Because up to 123, 2000
So
appeals
many
are-
matters, so many matters. 123, 124.
124, 15, 16.
Hmm.
27, 28, 1.
Huh?
27, 28, urgent.
What about 124? If nobody is there, we will appoint amicus curiae and finish it up. Now we can't keep on waiting like this. It is listed lastly in the year 2000, 2001. Paperwork is not yet prepared. No, 124 libo. None appears for the petitioner. In the second call, in the interest of justice, this is the matter on such. Next date, amicus curiae file kare. 25.
125.
Board देखो जी. Never ending process. See, in this matter, 125,
My lords.
7/11/2023, there is a direction. The petitioner might be age about 87 years. Mr. Rizvi, then the ACJ requested to obtain whereabout and well-being of the appellant by taking help of jurisdictional vigilance officer.
My lords.
Next date, please on. What is the
My lords, that
answer?
file is not with me. I will check it out, my lords. That
So this was passed in 2023.
it's some instruction must have come, my lords. I'm not having the file at present.
Right on. On 7/11/2002, 125, huh? On 7/11/2023, the following order was passed, para 2 and 3, para and 2 and 3. Mr. Rizvi, Learned Counsel for the state, submits that he has not received the instruction as yet.
My lords, I need to check it out, my lords. I'm not having the file at present. my lords.
No,
I may be excused for that.
Same order pass kar do na. Be that as it may, so SP so and so is directed to place on record the well-being and whereabout of the appellant. See, better see the level.
My lords, may not record that I have submitted that observation that your lordship made, that I have submitted that no response has come from the side of SP, so I may be misunderstood. My lords.
Right, no instruction since Mr. Rizvi is the file is not available with him. He is not sure about the instruction. Hence,
that file part, I will be in difficulty. lords.
But no,
I take some more time. my lords.
nothing. Yes,
I need some more time. to
I
come.
want that SP should be directed.
Aye.
I don't. No, सीटा कर दियो. However, no instruction has been placed on record.
Yes.
Hence, the SP so and so directed.
Yes. Yes.
Yes. He 87 years
Yes, ma'am.
old. When in 2023, now he is 88.
88.
He will not be.
Yes.
Yes. Next.
126,
126. Yes, 126 range. See, in 2001,
My lords.
he was 45 years. Now,
45.
kito? 45.
69, 70, 69.
इतने में क्या कर दियो? Same. ठीक है? SP. एंटर भी कर दी. MSP. तापरे 126 orla. 127.
127, 128 has been adjourned.
28 adjourned.
129.
129. 129.
जो 2002 रे 56 years थिला.
My lords.
बर्तन. नहीं 2002 रे.
Yes. 68, my lords.
The intention of COVID.
हाँ. COVID पर भी ये भी same order करो. SP so and so is directed to place on the. Well, I'll tell you.
My lords.
I'm passing all these orders.
My lords.
I'm fixing it on 15th, na?
15th, yes, my lords.
15th MPC. If no instruction is coming forward,
Right.
then I will request the Director Vigilance,
My lords.
Mr. Priyadarshi,
Mr. Jetwa, Yashwant Jetwa.
whoever it is
My
there,
lords.
to appear
To VC.
in VC to work out the
Yes.
solution. Nothing,
My
so that he will also be,
My lords.
he render help.
Yes.
So that worker, you people are also handicapped.
Yes.
No instruction is coming. How many days you will
My
wait? Something of that sort we will do.
Yes.
Okay. 129 हिगला same auto करियो. ठीक है? तापरे 130. 130 देखो. 130 भी.
My lords, I think from 2002 onwards, councils must be present, my lords. That
Since
problem.
not coming, what to do? We can't read.
My lords, may I request tomorrow caption may be included in the supplementary list that from item number 130 onwards, criminal.
Tomorrow, the matter where I have passed the order, those things will be removed from the list.
Yes, my lords. From 130 onwards, my lords.
Remove from the list.
हाँ.
Because it will be listed on 15. There
Up,
is no point.
हाँ, up to 123 नहीं आएगा. उसके बाद जो भी है
हाँ.
sir, वो आने दीजिए.
126 भी नहीं आएगा,
जी.
129 भी नहीं आएगा.
Apart from those matters, those have been adjourned. Next matters will be taken up
Oh,
at
that
2
will be
p.m.
taken.
So that caption may be there in the
No,
supplementary.
if remove, then it has to be taken up.
Yes, my lords.
Yes.
131, your lordship.
131? Yes. What do you want?
Prefer adjournment, your lordship. 2 weeks.
Why?
There is some
2 on 2, sir. What is the matter?
Next week or
Huh?
next week or 1 week after, I'll.
If everybody will do next week and this week, who will do?
Just now, Mr. Satpathy is not some difficulty, is not argue this matter. That's why I pray.
Let it be there on the board. Next.
132. Item 131.
He appeared there.
He requests to delete the name of senior counsel Mr. D.P.
Okay,
Dhal.
remove the name. Even if it is there, how does it make difference? Yes, forget. Yes, next.
132.
132. You can create 45, right? Who is the lawyer? Keep on talking, you will not get anything. For early hearing of the community. Thereafter, the matter was thereafter since the paper was not ready, the matter was adjourned. Thereafter, the matter was not listed till the when the matter is called up today, none ABS for the petitioner. In the interest of justice, least on such thing. In all these matters, I will appoint him a peacefully. Okay, next.
133.
That in the event none appears on the next date of hearing, this court will proceed with the matter
By appointing
proceed
Mike
with
Esquire.
the matter by appointing amicus curiae. That indication should also be there.
Yes, my lords.
Yeah.
133.
दाखिले पर 133 है.
Yes.
135.
133. 130.
Nobody.
Huh?
Nobody is going to give it.
But we have to pass order, otherwise we can't wait for them. Let us see. Otherwise, I'll appoint amicus curiae and finish it up. Matter is taken up soon. So, who is appearing? Mr. D.P. Das. Non-APS for the petitioner on the second call. In the interest of justice, adjourned to such and such day.
133. Today is not available.
Okay. Adjournment is sought on behalf of Mr. Das. This is the matter. Yes.
135.
135. Estimate has already been done and I have filed IA for substitution.
Yes.
Copy may be served on us.
What is the sentence?
Final pouch होती कहीं था.
Hmm? Are you aiming at a acquittal? Conviction, are you aiming at an acquittal?
Yes, yes.
Or
Very good case. Very
on
good
merits.
case. Already written note has already been filed.
Very
Once already had this honorable court and adjourned the matter.
where is that application? 25, 22.
Then to the adjourned.
394 application. Look, IA number 24 of 2022. This is an application with this application. By this application, the wife, who is
Yes.
the wife of the sole widow,
Widow, yeah.
this application was moved in 2022. She was 70 years that time. She is alive. The widow of the sole appellant raised inter alia, please to continue with the prosecuting the present criminality. For the reasons stated in the application, the said application is allowed. Condemnation of delay 25, application 25 of 22 IA. This is an application for seeking condonation of delay in moving application under section 394 CRPC for the reasons stated in the application. The application is allowed.
My formal objection, may kindly.
Mr. Rijvi, Mr. Rijvi has vehemently opposed the prayer made by the appellants. However, I'm of the view that the appellant, the widow of the sole appellant, deceased appellant, has a right to contest the conviction and sentence recorded against the sole appellant. Accordingly, the application is allowed. Yes, please the matter for final hearing.
Consolidated cost settlement.
Appellant is directed to file amended memo of parties within a week. Release the matter. 9 July. Take 9 July. Take it. Next 136.
136.
In 2006, he was 57 years. Today?
75 years. 75 years.
75. None appeals for the petitioner. When the appeal was preferred by the appellant in the year of 2006, the appellant have stated to be 57 years age. Therefore, it would be expedient to inquire about the well-being of the petitioner and well-being and whereabouts of the petitioner. Accordingly, SP so-and-so is directed to place on record the report in that regard, at least on 50. Yes.
137.
None appears for the petitioner. None appears for petitioner. Even in the second call, in the interest of justice, urgent. It is made clear that in the event the petition, the appellant is not represented on the next date of hearing, this court will proceed with the matter by appointing amicus.
Nobody is there, my lords.
Then they will
In
not
all
move
matters,
at all.
yes.
Next.
138.
Your lordship may query who is present in which item, and that will be more. Nobody is there, so same order can be passed in all appeals.
Anybody is appealing, they are appealing. May I just, कितने matters?
162 matters. Total 162.
On? As 140, till 140 I'll take
ठीक है
today.
सर, ठीक है।
From 140 onwards tomorrow.
54. Maybe tomorrow.
Let it be, I am till 140 I'll go.
Yes,
today. Yes. Because there is never ending then.
Yes, madam.
This will. Then APS for the appellant, despite second call, in the interest of justice urgent to so and so, it is made clear that in the event the appellant is not represented on the next date of hearing, this the court will proceed with the matter by appointing
amicus.
139.
940. Maybe weekly list for.
On the request of the learned counsel for the learned counsel for the petitioner submits that let the matters be remain in the weekly list, and she will be filing short written submission and address the court on the next and address the court. Address the court.
Some passover matters from the weekly list, my lord. On Monday, my lord, that has been passover, criminal matters. That may be tomorrow, my lord, that may be in the noting in the top of the list, such and such matter will be taken up, passover matter taken up, so that they will come.
You just suggest him.
My lord.
He is not going to pay you anything. Let it be there. At least if your name is there, you are coming to the court. Otherwise, you won't come. Let it be there.
Grateful, man.
अच्छा मोर टिके दौना दी की दो